Happy morning to one and all. Today we are going to discuss in topic Indian Contract Act 1872. Before the going the concept Indian Contract Act 1872, let us discuss about a law. Law means a set of rules. It may be defined as the rules of conduct recognized and enforced by the state to control and regulate the conduct of people to protect their property and contractual rights with a view to securing justice, peaceful living, and social security. There are several branches of law, such as international law, constitutional law, criminal law, civil law, etc. Why should one know law? One should know the law to which he is subject because ignorance of law is no excuse. For example, if Y is caught driving scooter without driving license, he cannot plead that he was not aware of the traffic rule regarding the obtaining of a driving license and therefore he may be excused. That is about of law. Let us discuss about Indian Contract Act 1872. So before the going the concept, let us know what do you mean by contract. According to section 2H defines that a contract means an agreement enforceable by law is a contract. Let us discuss that the contract must have the following two elements. The first one, an agreement. Second one, enforceability of an agreement. In the form of an equation, contract equals to an agreement plus enforceability of an agreement. So let us discuss the topic, what do you mean by an agreement. Agreement means, according to section 2E defines that every promise and every set of promises forming the consideration for each other is known as agreement. For example, A offers to sell his car for rupees 1 lakh to B. B accepts his offer. This offer after acceptance becomes promise, and this promise is treated as an agreement between A and B. Let us move the next slide. Proposal. According to section 2B defines that a proposal when accepted becomes a promise. When a proposal accepted, for example, if a person proposed to another, when other person accepted the proposal, that becomes a promise. Let us see the example. If A goes to a hotel and orders tea, he is making a proposal. Then what do you mean by acceptance? When one person signifies his assent thereto on the proposal made, he is said to accept the proposal. For example, when A orders tea and B supplies tea, it is understood that the proposal made by A is accepted by B. Let us move the next slide. In this slide, we discuss about promise. When a promise to whom proposal is made signifies his assent thereto, the proposal is said to be accepted. An accepted proposal is known as a promise. For example, when A asks B to lend him a book and B gives his assent to lend him a book, this is a promise, that is proposal by A to lend the book, acceptance by B by lending the book. This is the concept about of promise. Let us discuss the topic about of consideration. Consideration is nothing but something in return is called as consideration. For example, A offers B to sell his car at rupees 1 lakh. B accepts the same. Now for A consideration is rupees 1 lakh and for B consideration is a car. We can see the something in return. Here the return is A was selling his car for rupees 1 lakh. He wants the money of rupees 1 lakh. And B point of view, we can see that B wants the car. Here the something written is one is car and one is money. That is exchange between both the two parties. Until and unless there is no consideration, there cannot be an agreement. So if there is no consideration between two parties, it cannot be called as consideration according to the court of law. Let us move the next slide. In this slide, we discuss about enforceability. An agreement is said to be enforceable by law if it creates legal obligation. Obligation is a legal tie which imposes upon determinate person or persons the necessity of doing or abstaining from doing a definite act or acts. It is nothing but if two parties are doing a contract, it should be beyond the legal obligations. If an agreement is incapable of creating a duty enforceable by law, it is not a contract. So if it is unethical to the law, it cannot be treated as a contract. Let us move the next slide. In simple terms, contract means proposal plus acceptance equals to promise, promise plus consideration equal to agreement, agreement plus enforceability equals to contract. Let us discuss about Contract Act. All contracts are agreements, but all agreements are not contracts. Why? Because in this society we'll have two things. One is social obligations and one other is legal obligations. But the social nature, what are doing contracts, it cannot be called as a agreement. For example, agreements of moral, religious or social nature are not contracts. They are not likely to create a duty enforceable by law. Parties never intend to create a legal obligation. So this is the terms or conditions of the become all contracts are agreement, but all agreements are not contracts. Let us move the next slide. For example, X invites his friend Y to a dinner and Y accepts the invitation. If Y fails to turn up for the dinner, can he take his friend to court? X cannot go to the court to claim his loss. A father promises to pay his doctor ₹1,000 as pocket allowance. Later he refuses to pay. Can the doctor recover the amount? The doctor cannot recover because as it is a domestic agreement and there is no intention on the part of the parties to create legal relations. This is the meaning of a contract act, what that defines. A famous case about of Balfour versus Balfour, which is happened in the year 1919. A promise by the husband to pay his wife £30 every month. Later, husband refuses to pay. Wife goes to court. And the court has given judgment held that unenforceable as parties never intended it to be bounded by legal obligation. So here we can see that there is no legal obligation between the parties. So it is called as unenforceable contract act. Thank you.